Brandon, first name Brandon, last name Hutson.
All right, Mr. Hutson, I've got your mailing address on Prest in
Yes.
Detroit, okay? And when you met with Miss Kleeman, you gave her an email and a phone number, is that right?
Yes.
Is it okay if the court uses your email and your phone number to have contact with you?
No, it's fine.
Okay, thank you. State of Michigan versus Brandon Hutson, 22F21256. I have received a petition requesting a court-appointed lawyer. I will sign that. You may proceed when you're ready, Ms. Kleeman.
Thank you, Assistant Public Defender Melissa Kleeman on behalf of Mr. Hutson. And we have had the chance to meet and go over the complaint together. He waives the formal reading of the charges and stands mute.
All right, go ahead, Ms. Reiser.
Thank you, Honor. We're asking that the court deny bond in this matter pursuant to MCR 6.106. The defendant is charged with criminal sexual conduct in the first degree for the sexual assault of an 11-year-old autistic child. He's also charged with kidnapping and unlawful imprisonment. I anticipate that there will be additional CSC charges once the further DNA testing is done. He doesn't have any ties to the community. I believe he is a danger to the community, so we're asking that the court deny bond. The child was abducted from Ypsilanti in May of 2022. She left home on her bike. Her mother woke up at 11 p.m. to find her bike, and she was gone. She was dropped off the next morning in Ypsilanti Township by a green vehicle, and neighbors in the area found her outside and immediately called 911. She was taken to the hospital, and a SANE kit was performed, and that revealed the CODIS hit from the defendant, in this case, Brandon Hutson. He has a conviction in 2012 for unarmed robbery, where he spent 2 to 15 years in the Department of Corrections, and he was paroled, I believe, in 2018.
17.
All right, thank you.
You're welcome.
Go ahead, Ms. Kleeman.
Thank you. And I have had, again, the chance to speak with Mr. Hutson, and he did want me to let the court know that he does adamantly deny the allegations. In terms of his flight risk, he does have local stable housing at the address provided to the court in Detroit. That is a place that he has lived for the past 2 years with his aunt and uncle. He does also have local employment. He works full-time at a union job. He is the father of one 3-year-old daughter who he does provide financial support for. And I do agree that I saw the prior conviction for 2012 unarmed robbery, but I did not see anything that was similar to these allegations in his criminal history. He is not currently on probation or parole. He has no holds apart from a parking ticket out of Taylor, and we would have no objection to home confinement or to a no contact order, not only with the complaining witness, but with anyone under the age of 18.
All right. So this is my usual problem with denying bonds without having an evidentiary hearing. And I don't think that the court rule, Michigan Court Rule 6.106 regarding pretrial release sub B, sub 1, sub B, pretrial release. The court may deny pretrial release to a defendant charged with criminal sexual conduct in the first degree, armed robbery, or kidnapping with the intent to extort money. So this is not the correct kind of kidnapping. We're still just talking about CSC. If the court finds that proof of the defendant's guilt is evident or the presumption is great. This is not an evidentiary hearing. No evidence has been presented to me. The statements of counsel are not evidentiary in nature. I don't believe that I can deny bond under that court rule at this proceeding. The point is taken that the basis for charging is DNA evidence that matches Mr. Hutson with DNA from the SANE examination. which perhaps if that were presented as evidence, then the court rule would be met. But
And I'm
that's
happy to, if your honor wants me to forward the MSP lab report, I'm happy to email that. It's a,
not evidence, though. I'm not, this is not an evidentiary hearing. So I don't see, I mean, as I read that court rule, it has to be evidence. And so evidence is something that is admitted into court and through testimony. That never is happening at an arraignment. If I'm misreading the court rule and someone wants to brief me on that, I'm happy to read it. But that is the way that this court interprets that court rule, is that it needs to be based on evidence, and there will never be evidence in an arraignment. So having said that, I'm setting the bond at $250,000 cash or surety, no 10%. No contact with the alleged victims, no weapons, no illegal drugs, no leaving the state of Michigan without permission of the court, no criminal behavior, no assaultive behavior. The probable cause conference will be on September 1st at approximately 9 a.m. We're all set on this one. Thank you.
Thank you.
You're all set, Mr. Hutson.
Okay, okay.
You have a question?
No, this is all news to me. This is all, so everything's weird that's happening right now. So
Yeah, I know. Someone from Ms. Clayman's office will come and talk to you soon.
I'm a little annoyed out. I'm a little weird. Everything's just a little weird right now.
All right, I understand. Someone will come and speak to you soon.
Thank you.
Thank you.
Thank you.